$4,500 per month without any deduction or set-off whatsoever, and that's paragraph 3 of the lease. Tenants, what really kickstarted this dispute, tenants set off $2,800 from the June 2025 rent when they unilaterally placed the hot water tank on the property in violation of the lease. Tenants have not paid rent since August of 2025. From my knowledge, tenants are supposedly placing the rent in their attorney-client escrow fund. They're paying contractors and for supplies with the rent money owed to landlords. Tenants are operating their commercial horse farm rent-free on the property during the pendency of their circuit court action. Tenants admit to withholding rent, so there's really no factual dispute here. Right now, I believe the base rent owed is $24,800.
Your Honor, I know that you are a very thorough judge, and I filed an answer to plaintiff's complaint to recover possession of the property. In that answer, I listed out the situation that led to our filing a breach of lease complaint in the circuit court. The property has, and it states so in the lease, has been used as a horse farm. It's zoned agricultural for over 25 years. About a year and a half ago, Erica notified the landlord several of the outdoor sheds that shelter the horses had deteriorated to the point where they fell down.
But what about the provision that the base rent is going to be paid without deduction?
That is if they live up to all of his responsibilities.
Is it conditional? That's not what I read.
It is not conditional, but in any contract where one party breaches several...
I have two businesses, in essence, that have entered into a contract. That contract can read various different ways. I mean, you're trying to say that there's a general reading for contract. Maybe if it weren't two businesses operating at arm's length, you might be correct, but that's not what I have.
No, we have a lease, and under Michigan landlord-tenant law...
Where is that base rent now?
So, in June, they notified him to please repair the hot water heater. He did not. They repaired it themselves. They withheld the cost of the hot water heater. Aaron did the labor installation himself. They paid him the difference between that withheld for necessary repairs that the landlord is duty-bound to provide under the lease, and gave it to him. He then...
That's June.
That's June.
Okay, what happened in July, and where's that rent?
Yep, they paid it.
August.
We started withholding in August 1st. In July...
So, all right. No, not really.
No.
You
Okay.
ever do that to me again, you'll be out in the hallway.
Thank you. I apologize. I was not trying to.
August, September, October, where is the base rent?
The tenants told the landlord that they were going to have these things repaired, and that they were going to withhold the rent to make the repairs.
Why can't I just get an answer to my question?
And after they notified him, he had threatened to take over the farm, insert his own manager, and they paid the rent into an escrow fund, out of which the necessary repairs were made. They withheld the rent to make the payments to the contractors that were filling the dangerous holes in the pastures.
Where, out of what account?
They paid the account into an escrow fund that I held for them to be able to pay the contractors for the necessary repairs.
Also, like the last case you were here on, now we have a problem. I want to know where the escrow is.
The escrow is in my, it's all paid out. The escrow funds are all paid out to the contractors. They paid this month's rent.
Do you see the problem here? Do you?
Well, I know you want me to see the problem, but
Then that must be the answer is no.
No,
You took client money in.
I withheld rent.
And then dispersed it.
I withheld rent under the tenant.
But you can't on your own then disperse it.
They dispersed. Erica Ward signed those contracts and paid those contracts.
So, if as a tenant, they elect to set up an escrow account to put their rent into, show me the authority that then permits them or their agent to disperse those funds.
This was not.
Show me authority for that. Because I'm going to tell you, you're not going to find it, Ted. Or you might be in violation, and I'm not saying you are, and I hate even making the accusation, of ethical rules that would apply to attorneys taking clients' money into trust. I
understand.
And again, I will give this blanket statement. I am not saying that making any accusation. I'm not making any finding. I'm not saying any of that. I'm not saying even to a great extent my analysis, if I were to come down to the end of it, is correct. All I'm saying is that's what I see on the surface. But we have another problem here, because not only was that part done, but as I'm to understand then, those funds were then dispersed elsewhere. That creates a whole different ballgame, particularly where you're claiming a breach as to who did it. So while I recognize and understand what you're saying, it's all a mess, and they're sort of a mess on both sides. Less of a mess over here, more of a mess over here. I gotta try to clear that mess before I can even begin to deal with that. I really don't have a dog in that fight. There's no reason for me to say it other than the fact that you're facing jeopardy on a number of different. And so I'm going to do this, and I realize that it delays plaintiff, but I think the court is compelled to do this. I'm going to adjourn 1 week to the 21st at 3 p.m. The basis upon which I'm adjourning is, I think, Miss, you need to get the advice of counsel as to how you should move forward, and if you should that account.
I was.
There's a problem.
But not my attorney.
Okay, so no. That's our problem. So, who else was a signatory to that account?
No one else. Me and me alone.
Do you not see a potential problem with that, Ms. Tobe? That's a yes or no. If you don't, I don't know what to say.
I see that someone could make an issue out of it, but I don't see a legal problem.
Don't you really yourself become a necessary party to this action? And that's what I'm saying. And if you're a necessary party, Ms. Hope, you can't be the attorney. Mr. and Mrs. Ward, do you understand what the court is indicating? I mean, whether you agree with it or not, it's not my issue. You understand what I'm getting at?
Yes.
And so that I'm clear, and what I was trying to be clear at the last hearing, was I did not want a circumstance where, Ms. Hope, you're brought in as a party, and then your clients are left without representation. Ms. Hope, with that understanding, what are we going to do? I don't want to get so far down the line.
We're off track, for sure.
That what?
We are on this case. We are off track. I will prepare withdrawal papers and have them sign it. We talked about this. They're in agreement.
All right. So you're going to withdraw as counsel?
Yes.
All right.
Your Honor, my client would like to say a few words.
That's fine. Yes, go ahead.
Thank you.
Your Honor, so my background is I'm a family man with 6 children. This property is our family's entire retirement. I was adopted, worked my way through school, started a mortgage company in 2003 that's operated for 22 years. without a single bad review. I've served on the board of the directors for the Arthritis Foundation and Entrepreneurs Organization. I work with the Congressional Medal of Honor Society. I spent over 10 years coaching and sponsoring at-risk youth for football and baseball, including future Maryland running back Nolan Ray. We have saved our entire life to be able to purchase this property. The tenants have been operating a business on it without paying rent. They've made false statements about me, potential future buyers. They've contacted my land contract seller to try and usurp me and purchase my debt. The land contract seller contacted me to alert me immediately and denied them.
I will expeditiously get this matter to trial if that's where we have to head. I don't have a problem doing that, but I can't set things when things are in such disarray, quite frankly. The 2025
Call from the last hearing, you adjourned to give plaintiffs time to seek alternative counsel.
Right.
It appears that they used that time to file a dispositive motion and an omnibus motion for repairs, and Ms. Tope's motion for withdrawal 2 days before this hearing, which I received a copy at close of business on Wednesday, which forced landlord to file its own MSD, which was filed with the court this morning. So it appears it is further delay by tenants, and it's another month with my client not receiving any rent payment.
And there's the twist. After multiple pre-trial hearings and all this procedural chaos, the plaintiffs apparently respond by filing a dispositive motion, basically asking the court to resolve major parts of the case without going to full trial. That's a power move. It signals one side thinks the law is so clearly in their favor that a trial may not even be necessary. But with this much courtroom confusion already on display, do you think this case is anywhere close to finished?